First question you might ask yourself is, who in the world is this guy standing in front of you? Right? What is he? You know, does he work at a grocery store? Does he? Is he a barber? What does this guy do? No, I'm a lawyer. I've been doing this for a few years. So let me introduce myself. I am a graduate of Boston University School of Law. I've been practicing out here in California continuously for over 26 years now. I had to do that. Unlike our former Governor Pete Wilson, I actually passed the bar on the first attempt, so I was very happy about that. About 16 years ago, I formed the Schomer Law Group, a law firm that is solely focused and dedicated on the topics that we're going to cover today at the seminar. Those include probate, wills, trusts, Medi-Cal planning, asset protection, estate planning, conservatorships, all the things that we're going to be covering today. So we don't do workers' comp, we don't do personal injury work. We do dabble a little bit. I spent a decade before I started doing this work doing real estate litigation. So I actually have a very extensive background in title disputes and partnership disputes, and I've worked for companies as big as Nissan solving their title problems. So, and a lot of what we deal with in the probate court is actually title problems. So I have that, but this is what we do. So I've been recognized by my peers as one of the top people in this area. Almost for the last 9 years running, I've been designated a California super lawyer. I'm also a 5-star wealth manager. I'm also a financial advisor, because when we do planning and we help people structure their estates, it's important to have good financial advice. And I'm also a member of the Multi-Million-Dollar Advocates Forum, a lifetime member. That's an award given to less than 1% of the attorneys in the country, and it's because I've taken cases to court in this area and won judgments and verdicts in excess of several $1 million. And very few attorneys can say that. So that's who I am, but the name of the firm is not Scott. The name of the firm is the Schomer Law Group. And like a family and like many things that we do in life, you're always better with a team and a group around you. So let me give you a brief introduction to some of the team. We're a total of 12 folks all together in 2 offices. We used to be literally right across the street. If you remember where the old Cafe Edelweiss used to be, that Swiss restaurant. Actually, I think the MedMen is there now in our own space. But we just recently moved up to El Segundo, about 2 miles up the road. We're very close to the PCT tower. Let me introduce you to the rest of the team. First up is my associate attorney, Laron Aliav. Laron is a local boy born in Tarzana, UCLA Law School. I'm sorry, UCLA undergraduate. He's a Bruin. Sorry, Teresa. But we have some Trojans. Don't be afraid. Went to Loyola Law School. And Laron likes this stuff so much that he hung around an extra year to earn a master's degree in taxation law. Ooh, can I see show of hands who gets excited about tax? No, not so much. No, okay. Well, he likes it. Very smart young man. He's spoken before the Professional Fiduciaries Association of California, and he's also been recognized by his peers as a rising star in this market, because he's done an incredible array of things in the last 5 years he's been with us. Next up is my other associate attorney, Megan Waugh. Megan is a native of Peoria, Illinois, and she graduated from Pepperdine Law School. Go Waves. Go Waves. Go Waves, right? Not a surfer, actually. She focuses her practice on the probate court and probate litigation in particular. One of the more remarkable things she accomplished in the last year and a half is she helped with our conservator client rescue a senior in Beverly Hills who was living in absolute horrible squalor. They put the home and cleaned it up, put it on the market, and the thing sold for $16.2 million. We think it was a record in the Los Angeles probate court, the most expensive house ever sold there. So she did it. She handled the whole thing soup to nuts. Very proud of her. She's now actually helping administer the estate on that. And she also has been recognized by her peers as a rising star. Next up is the attorney in charge of our Orange County office. Our Orange County office is in Los Alamitos, just south of Long Beach, if you know the area. Very close to the high school where Laura Bromlow's children attend, so we're happy to be able to support that. Laura has been practicing this area for about a decade. Laura's so smart that she's licensed to practice law in 4 states. It kind of makes my head explode. I can't even remember all the states she does. But Laura has a particular focus and emphasis on helping people claim benefits for Veterans Administration. So if you're a veteran or married to a veteran, you can get special benefits when you get to be a senior. And also with Medi-Cal planning, which is, I think you were the one that asked about that earlier, that's her real big passion. So in addition to that, we have a whole team of paraprofessionals. We are actually 12 folks, and right there, a little bit to the right is Eve. Teresa was asking about Eve earlier, but the whole team walks, eats, and breathes this stuff. So you can talk to almost anybody on my staff, and they know the answers to a lot of these questions. What's the difference between a will and a trust? Which one's better? What does it take to go through probate court? You'd be amazed at how much they know, because we all love this stuff and we want to help people. So that's who we are. That's what we bring to this conversation. We love this topic. Like Teresa, we really believe in education. We really believe in helping people. And one of the big reasons is, just like Teresa shared her story, we see so much heartache out there. There's just nothing worse than helping a family pick up the pieces and have to do this thing the hard way, the difficult way, the expensive way. There's so much pain you can save your family if you just spend a little bit of time and plan. We'll talk about that. So in addition to our extensive team, we are also members of the American Academy of Estate Planning Attorneys. They are a national organization. They are recognized as one of the leading organizations. It's really a seal of approval. But we're part of a network of attorneys across the country. So if you come into my office and say, well, you know, Mama left me some property in Baton Rouge or in Maine or in Kansas, most likely we have somebody there that can work with us, that can help us, that can solve your problems from soup to nuts. And if you're a reader of Money Magazine said if you're looking for an estate planning attorney, look for an Academy member, that's us. And also if you're a fan of Susie Orman in her book, 9 Steps to Financial Freedom, she also said, look for somebody that's a member of the American Academy. And that's who our firm is. We are folks that go to seminars, summits really twice a year. We have to do triple the amount of education that most attorneys do. So every year I get 36 hours of education, whereas most attorneys only have to do 12. But I like this stuff. I like teaching it. I like learning it. It's important. So, but you don't have to take my word for it that I think we're the best firm in town. We invite you to check us out. So we have a very substantial presence on the web, including articles and blogs. We blog on a regular basis. I think we have a pretty fun Facebook page, which puts relevant articles and all kinds of stuff. So look at us, check us out, do your research. All right. So from the top, and those are our sites. So from the top, we're going to be talking today about the 7 costly mistakes that families make with estate planning. To help this analysis, one of the things that helps you to know is what are your basic options when you're looking at estate planning. So I'm sure you're familiar with some of these, if not all of them, but we can go through them briefly. So first up is spend every last dollar. You may have seen this estate plan on the back of a bumper sticker. Anybody? Yes? No? I'm spending my kids' inheritance? It's a popular one. So it's certainly an estate plan. It's another way of saying you didn't plan. And it can be a lot of fun as long as the money lasts, but you can run into problems if you don't time it correctly. So that's one option. Option number 2 is to die intestate. Now, I know that sounds like a nasty disease. Sounds like Ebola or something, right? But what it basically means is you didn't do anything. You failed to plan. That's the technical legal word, dying intestate. And if you died intestate, the government has a plan for you. Aren't you excited? Jerry Brown wrote it himself. He's just waiting for you to come say hello. Number 3 is to do everything in joint tenancy. Now, especially as realtors, you're probably very familiar with joint tenancy, or the more recent form, community property. Joint ownership is community property, which is very common on a lot of deeds. This is probably the most common form of estate planning, but it also often causes the most heartaches and problems. I just finished representing last week. I was defending a sitting judge of the Superior Court over a title dispute where his attorney father put him on title to a property, and they were battling it out for 2.5 years. It was the most heartbreaking case I've worked on in a long, long time, but we got a very good result, so we were very happy. So option number 4 is to create a simple will. And that comes to our, what's the difference between a will and a trust? And do you need both or just one? So we'll talk about that. Next is to create what I call bare bones living trust. I sometimes refer to this as doing backyard estate planning or downloading forms on the internet. I remain continuously shocked at the various things that people walk into my office and say, well, I've got my estate plan, here it is. No, that's not. And then the last option is to create something called a complete family wealth legacy plan. And that's where you, simply stated, you just do it right. You work with somebody that knows what they're doing, and you create a full plan. So as you're thinking about your options, and you're thinking about, where are my assets going when I'm not here anymore, who's going to be in charge of them, this is basically the landscape of where things are. You either spend all your money, or you just don't even think about it and fail a plan, or you create one of these basic, simple things. Now, one of the most shocking things to most people that they don't realize is almost every single one of these options has potential pitfalls, right? And our challenge and our goal is to minimize the pitfalls and make it as easy and smooth and simple for your family as possible. As Teresa talked about, her father had enough presence to write a will. A will gives directions and directs things, but it has some downsides, and we'll talk about that. Okay, so estate planning, mistake number 1. That is no protection to pass on your hard-earned wealth without government or court interference. And what I'm talking about is the probate court, either in conservatorships or when you pass. So this is really our second option. You either become incapacitated or you die intestate. And it comes back to the simple slogan, you either make a plan or the government has a plan for you. This is the government's plan. It is probate court. So first up, who in here has heard about conservatorships? Show of hands. Anybody? Okay, that's more than a lot. Who's actually had experience with a conservatorship? Anybody? Oh, you folks are lucky. Good for you. So you may not be familiar with the term conservatorship, but you're probably familiar with the term guardianship, right? You ever watched that movie with your kids, Little Orphan Annie? Right? A guardianship. A conservatorship is a guardianship for an adult. They're the same thing. So if you're under 18, you go under a guardianship. If you're over 18, you go under a conservatorship. And what it is you're basically saying, this adult is no longer capable, she's become like Little Orphan Annie. She's no longer capable of managing her affairs. I want to be her daddy warbucks. I want to be in charge of her legal affairs. So the first thing you need to know is with a conservatorship, what it is a lawsuit. So if we're talking about your mother, you get the privilege of suing your mother. Isn't that exciting? And you file this petition, you file this lawsuit, which is really what it is, and you allege, my mother's incompetent. Now, I don't know about you folks, but my mother would not take that news well. I raised you, what do you mean I'm incompetent? Okay? Fortunately, my mom's not in that situation yet. But that's what you're having to do. You then have to go into court and convince a judge, this is what we want to do. We want to be in charge of mom's affairs. We want to run her situation. And everything has to be decided by the judge and basically managed by a committee of lawyers. A committee of lawyers headed by the judge. You're like that, that's right. Who would be excited to have a committee of lawyers running their life? Anybody? No? Not even me. Right? And I am one of these things. So that's a conservatorship. The other thing is the other issue is probate. This is for when you pass away. Death probate. So if you pass away and you have assets in your individual name, that are not in some type of probate avoidance device, then you are going to go through a probate administration proceeding. Okay? So what is probate? Well, somebody smarter than I once described probate as a lawsuit you file against yourself for the benefit of your creditors. Another show of hands. Who would like to sue themselves? No? Wow. Not even me. That's the purpose of it. So your friend passes away, your father passes away. You are filing a lawsuit in re my dad, in re Peter Schomer. You file it in the Superior Court. You pay the same fees as a lawsuit. You go in front of the judge. You got to prove your case. You got to prove evidence. If there's a will, you could have a fight over who has the will, whether it's legitimate, all these types of things. It can be a bloody nightmare. So besides the obvious, why do you all want to avoid these things? Two big reasons: time and money. Two of our most valuable things, right? First up is it can be very expensive. You've got to pay court fees, publication fees, bond fees, executor and attorney's fees. The average cost in California for probate is 4 to 8% of the gross value of the property. Let that sink in for a second. 4 to 8% of the gross value of the property. So if you got $1 million piece of real estate, which in this neighborhood is not unusual, you're looking at about $50,000 in fees and costs to transfer that piece of real estate to your loved ones. $50,000. So can I have another show of hands? Who would like to pay me $50,000 today? No, yeah, I didn't think so. Most people would. So that's really expensive. The next thing is that it is time consuming. The minimum amount of time to get one of these things through probate is 9 months. In LA County, realistically, what you're talking about is about 1.5 years to wrap up and close a probate. And what that means is during that time period, you're going to have limited access to the funds that are in the probate. So if there's a loved one that needs support, or a child that needs to have money, or have his or her school paid for, or travel expenses, or medical expenses, all that stuff, all of it's going to be restricted. And certainly you can, depending on the circumstances, you can ask to have that changed, but guess what that requires? Seeing that guy, right? Or that gal. You have to go petition the court, have to make a request. All of it means more money, more money, more money, right? These things sometimes are open several years. I've worked on a couple of probate estates that have been open for more than a decade because they take that long. And if you have assets in other jurisdictions, you're going to have multiple probates. So I've worked on a couple of cases where the decedent lived and died here, but again, he inherited from his mother a piece of property in Alabama, or in Michigan, or in Ohio, or some other place. And you end up having to open up a probate here, open up a probate there, opening up another probate somewhere else. And you've got to coordinate all these things, and it's just fees, costs, and expenses. It is a pain in the backside. So living probate, I talked about this a little bit earlier, or a conservatorship. This is if you have a stroke or you become incapacitated. And again, it is another lawsuit that has to be filed. And what's wrong with this besides the obvious? It is humiliating. Again, you've got to allege that your mother or your father is incompetent, or your loved one. I've had to do this between spouses. I've had to have a wife come to me and say, my husband's severely mentally incapacitated. Some of you would like that, right? I'm sure there's times where my wife would enjoy that as well. But, it's time consuming. All your personal information gets disclosed and filed with the court. And it is expensive. Again, you have court fees, you have attorney's fees, you have conservatorship fees. On average, what you're doing is you're looking at about $10,000 a year to handle one of these conservatorships. Okay? All of which could have been avoided by a little simple planning and kept you out of probate court. So that's a pretty big mistake. Mistake number one is not thinking through this and not protecting yourself from government interference. So mistake number two, we're talking about the seven mistakes here. No nursing home protection. So you might have a plan, You might have joint tenancy, you might have powers of attorney, you might even have a trust. But does your trust anticipate the cost of long-term care? Many people go broke from nursing home costs and charges. The annual cost of nursing home care in Los Angeles County is now almost $100,000 a year if you need that level of care. And who's going to pay for it? So how do you do this? Well, the basic options you have to pay for long-term care are, first of all, using your own money, writing a check, right? Not a lot of us can write a $100,000 check on an annual basis. Number two is you can buy long-term care insurance. But long-term care insurance is pretty unusual. Most people do not carry it. And if you go to get it when you're about to check into the nursing home, you're not going to get it, right? It's going to be too late. Number three is you can apply for limited Medicare benefits. So depending on how you access the system, Medicare will give you about 100 days of coverage. They'll pay for that. But if you've ever dealt with a senior or somebody that's had to go through some of these issues, you know 100 days isn't squat. It's not going to cover much. The next is to qualify for some kind of Medi-Cal benefits, or number five is to qualify for veterans aid and attendant benefits. So we had a question about Medi-Cal benefits here. Medi-Cal benefits, nursing home costs. So that's the basic issue that you face. Let me delve into this topic a little bit more. The government has a program that in the rest of the country is called Medicaid. Here in California it's called Medi-Cal. The basic idea is that it is a program for the destitute. We don't want our seniors laying on the street and passing away when they get to be too old. Okay? So if you are destitute, if you have no assets, the government will pay for your long-term care expenses. Okay? They will pay for your nursing home costs, so you don't have to pay $100,000 a year. So how do you qualify for this program? Well, it's very complicated and there are a bunch of different rules, but the basic rule is you cannot have more than $2,000 of assets. Right? So if you're sitting on this nice little retirement fund, or you have all this money sitting in a retirement account, the government's going to look at you and say, you need to spend that down. And when you're down to $2,000, you can then come see us and apply, and we'll start paying for the care. That's the idea. Now, there are a number of different exceptions to this rule in a number of different ways. If you're in the real estate business, you may know one of the big exceptions is a residence. You own a residence and you intend to keep the residence, even though you're not going to be able to move back into it, the government will not count that against your $2,000 eligibility standard. So we take two different couples. Couple A, or let's say client A has a $1 million house and $1,500 in the bank. Boom, she can get right into the Medi-Cal coverage. Client B has a $500,000 house, but has $200,000 in savings. She's not going to qualify. She's going to be required to spend that cash down until she gets to $2,000. She can keep the house. And by the way, if she wakes up one day and says, hey, I'd like to sell the house so I have more cash, boom, her pile of cash then goes up and she has to spend that pile of cash down. Okay? So there are some very interesting ways to deal with the Medi-Cal issue, and we are experts and know how to be able to qualify people and preserve and protect your assets. I can't cover all of them or the big strategies, but just sort of that little taste, I think, gives you an idea that if you haven't planned for it. So here's the other really big important thing that you need to know, is a lot of times when you need nursing home care, you can't make decisions about your estate. In other words, you've had a stroke, or you're in a coma, or you're in such severe mental impairment that you're not able to do something. You cannot, in that state, go into the probate court and say, hi, I'd like to do some Medi-Cal planning and give my assets away so that I don't have to pay the government. I don't have to pay for nursing home costs, the government will pay for it. The probate court looks at you and says, but we are the government. We're not going to help you do this. We're not going to do anything to help you. So one of the most critical things from my standpoint when you're talking about Medi-Cal benefits is you want to have a good plan in place. You want to have a thorough living trust, one that allows for Medi-Cal planning, one that specifically anticipates it. You want to have very well done powers of attorney, healthcare directives. So if you're unable to do this type of stuff, you've got people that can do it for you. And this situation came home real recently. We helped a family of sisters. I helped the mother first. I restated the mother's trust, helped her. She passed away. The two sisters came in, lovely, lovely people. I administered the trust for them. We divided the assets, we figured it all out. I did the sister's estate plan. Well, the sister recently got in a horrible accident. She was only in her early 50s. She had a horrible fall, and she's been in a coma for the last 6 months. And now basically everything that she's worked to protect and preserve, she is at risk for long-term care because she is in a nursing home. But the good news is that she had the foresight to plan with us ahead of time. So we can guide her sister and we can protect her assets. And we can keep them there both to take care and supplement her care in the nursing home, but also to leave a legacy for her beloved sister and nieces. So it's a wonderful thing. So you have to think about this kind of stuff ahead of time. Because if you're laying in the hospital, that time is too late. All right, planning mistake number 3, not thinking through divorce, creditor, or lawsuit protection for your beneficiaries or heirs. Right? We're going to cover in this one what I sometimes call the Nintendo problem, or you might call it the Nordstrom's problem if you're a fan of Nordstrom's, right? Uncontrolled shopping. Kids get divorced and the family assets go to family strangers. Predators and opportunists take advantage. The kids get in trouble with lawsuits or money, or they're just simply financially immature. Have you thought through these issues? Are your loved ones prepared to receive $500,000 today? I had a gentleman come to my office yesterday. His daughter is 14 years old, and she's got $500,000 coming to her. Is a 14-year-old ready to manage $500,000 in assets? I mean, she's blessed, but I've actually seen situations where kids have literally killed themselves because the governors are off, the adult supervision is gone. So let's talk about divorce protection. So the first thing is that if you leave your estate to your children, let's say your daughter, you may be perfectly content. My daughter's mature, she's grown up, she's fine, she's going to do the right thing. How do you feel about her spouse? Right? Do they understand how to manage the money? Is the spouse in a good situation? Is the spouse going to take care of her? Because if that check hits their joint account, gets commingled, and he files for divorce 2 weeks later, guess who gets half? The son-in-law you never loved. Yeah. Or the daughter-in-law that you always thought was mean. Is that where you want all of your assets going? Have you thought through this issue? With a little bit of planning and creating the right type of trust, you can keep all these assets separate and send a very clear message to your sibling or to your children or your loved ones that this money's here to protect you and maybe your grandchildren. What about lawsuits? There's ways that you can leave money to heirs in irrevocable trust. That was a question we had earlier, and I'll talk more about this later. It gives asset protection for the next generation. Why wouldn't you want to do this if you can do it? It's a wonderful gift. Financial maturity. This is the Nordstrom's problem. This is the Nintendo problem. Right? I've had estates. One of my, I call it my favorite, but it really wasn't my favorite. But I had a gentleman that fought to get his mother's, part of his mother's estate. I helped him for 2 or 3 years. Literally got his check. He got about $100,000. Went right out and bought a Corvette. No. Right? Because he had never owned a car. It didn't occur to him that he needed insurance. He wrecked it about 2 weeks later, not only lost the Corvette, most of the insurance, but was also facing a lawsuit for the accident that he got into. Okay? I've had better ones than that. I've had probates that I filed where I get a letter from agencies. Hi, Mr. Schomer, I understand you're probating Susie Jones's estate. And I understand that Susie's daughter, Tammy, is getting a percentage of that estate. Well, she's not, because you're sending it to us to reimburse us for all these debts and claims. That's where the money needs to go directly. And they have the right to do this. They have the right to file claims. IRS does, the FTB does, creditors do. Everybody has the right to pounce and go in and get these money. Back taxes, all these things. Is this where you want your money going? Is this, to make up for the sins and the sort of poor management? I mean, it's horrifying. And this is one of the biggest things that most of my clients are worried about is, are their kids, are their loved ones ready to inherit or receive a big check? Remember that when you're thinking about your estate, it might not just be your house and some bank accounts. You might have insurance policies. How much insurance do you carry? Especially if you have children. Are they ready to be able to handle that kind of wealth? And then, of course, remarriage protection. Sometimes we cynically refer to this as the pool boy problem. Or maybe the female masseuse problem. Okay? You pass away and you leave your hubby. What's he going to do? Is he going to remarry somebody? We've had a bunch of cases where the surviving spouse marries somebody significantly younger, sometimes the age of the kids are even younger, and then leaves the entire estate to the kid, to the new wife, right? And then the kids go, how did this person who's my age take our entire family legacy? Have you thought through that issue? Do you know where it's going to end up? And sometimes it's not even intentional. I had a case once where an 87-year-old met somebody and decided to marry him, probably actually on their first lunch date. And he had a new estate plan written for her within a week. And she was gone 6 months later. And the entire estate went to this new husband. And the son saw nothing. There was literally nothing that he could do. So especially if you come from a blended family or you've had multiple marriages, this is something that you need to sort of think about. Who's going to be in charge? What's going to happen? Do I want to protect my share of the community? Because if you're married, you have a community, you're working together, you each have rights to it. You each own half of it. Is your surviving spouse going to do the right thing? And do you need to be worried about this stuff? Planning mistake number 5. No protection for retirement. So most of us, and even most estate planning attorneys, simply think about beneficiary designations on retirement accounts. Okay? And again, I have cases where somebody has an IRA, somebody has a 401k, and they leave their daughter or their son, who's 10 years old, as the beneficiary on the IRA. Have you thought through what's going to happen with that? Is the kid even capable of rolling it over? The short answer is they're not by themselves. What they have to do is then go into the court and get a guardian appointed, even if they have a surviving parent, so they have the authority to be able to do this. More fees. Also, there's missed opportunities to maximize income and protect beneficiaries from taxes. So one of the most heartwarming cases that we were able to help a client with is, we had a gentleman that came in that had a couple of kids that were in their early, just crossed the 20th year threshold. And he had done well enough that he each had a house for each of them. But he had a nice little sum in his 401k, and he looked at me and he said, what I'm really worried about is I'm going to give each one a house, but that they're going to take this retirement money, they're going to pull it all out, pay all the taxes, and they're going to wake up at age 32 on a beach in Tahiti and say to themselves, I've got no skills, where's my life gone? I've had a lot of fun, but I've got nothing to show for it. How do I protect this? How do I make my retirement their retirement? It can be done, but it doesn't happen by accident. You have to sit down and plan and actually do these things. So we were able to do that. the kids probably grumble at me from time to time, but because they're not getting all their retirement account till they retire, but we've protected it for the next generation. We did what the father wanted. The father was our client, so that's the important things. Mistake number 6, backyard estate planning, bare bones estate planning, do it yourself. So Teresa was asking me earlier, you know, what does our practice look like? So about 1/3 of our practice is doing the planning and protecting families. About 1/3 is doing administration. And 1/3 of it is doing courtroom, trial work, what they call litigation, doing trials. And most of it relates to this very topic. It is ridiculous the mistakes and things that happen. You know, so when you're looking at this, you know, do you understand the basic requirements of a document? So let me ask you this. Does anybody know whether or not a will needs to be notarized in California? Who would say yes? The will needs to be notarized. Yes? So we got about, I'd say about 20%. Who would say no? About 60%. The answer is no. You don't notarize a will. A will gets witnessed. And I can't tell you how many times that I've had wills that have been submitted to the court with one signature on it by a notary. A notary should know this. I went through training. I've been a notary public for almost a decade. You're supposed to know that you don't notarize wills. People do it all day long. I've also had people that have had powers of attorney sign wills. And I've had some of these document shops. I don't want to say any names. It does rhyme with we the steeple. But they literally charged somebody about $1,500 to prepare an estate plan that included a will signed by the agent under a power of attorney. So stop and think about that for a second, right? So the agent was the sister, and the sister was laying in a hospital bed dying. And the agency told her, oh, it's okay for you to sign your sister's will. Now, I would guess that most of you in this room are not lawyers. Doesn't that sort of make sense that I can't sign your will and you can't sign mine, right? You have to sign your will, right? That's basic. These people didn't understand that. And in that particular case, not to harp on this one too much, we had a situation where the sister had 2 siblings, so 3 kids. Dad was gone. Mom was living in a nursing home in another state, the state of Tennessee. Sister had one request out of her estate plan that they paid $1,500 for. I want to leave my estate to my 2 siblings. That's it. I want to do a trust, and I want to leave it to my stay out of probate court and do it to my 2 siblings. Well, they did this plan. They did a trust that they didn't fund. We'll talk about that a little bit more. They didn't fund. The sister signed the will, so the will was no good. We went into probate court, and the probate court said, yes, you've got this paper that looks like it's an estate plan. It means nothing because it was not done correctly, because it's not legal and it's not legitimate. So you are now, your sister has now died intestate. And when you die intestate, there is a set of rules about where your assets go. So sister dies, anybody have a guess? She's not married and no kids. Anybody have a guess where her assets go? The state? That's not a bad guess. Anybody else? Next of kin. Who's the next of kin?
Mother.
Goes to her mother. Where's her mother? In a nursing home in Tennessee. Guess who gets the sister's estate? The state of Tennessee, the nursing home. Now she's got assets. It all goes to the sister. It all goes to the mother. The one place she didn't want it to go, and it all gets taken by the state of Tennessee. So this little $1,500 bargain estate plan that was completely ineffective did everything absolutely wrong. Completely blew it. It was absolutely heartbreaking. So, and I have people that come to my office, oh, I have a trust, here it is, and they'll send it to me. And I'm like, that's a power of attorney, or that's a will. Oh, well, that's the same thing, isn't it? It's not. So do you know the requirements for a will? Do you know what the essential parties are? I had a case about 3 years ago where an attorney, first of all, didn't understand the difference between a will and a trust, should have absolutely written a trust, instead wrote a will, and then forgot to describe where the major asset went. The major asset of the estate was the house. So here's how the will went. The will went, I appoint my daughter, I leave all my jewelry and personal property to my daughter, I disinherit my son, signed. I'm like, where's the house? Where's the residue? Where's the rest of the property? When you leave a clause like that out, what the court does is they imply the rules of intestacy. Okay? So I just told you that she had disinherited her son. She had 2 kids, son and daughter. All right? She disinherited her son. The law says that they don't care about the disinheritance clause because she forgot to describe where she wanted the house to go. Okay? In a will. So the probate court literally had no choice, should have, but for our excellent advocacy actually, should have split this estate between the 2 siblings. But absolutely critical. So do you know the difference between these documents? Do you know the essential parties? Do you know the requirements for authentication, essential terms? Have you missed an important detail? Because attorneys that don't do this on a regular basis miss those important details. One of the things that I'm most proud of at the Schomer Law Group is we are now currently representing 2 judges. One that's an active sitting judge in the Superior Court, another one is a retired judge of the Los Angeles County Superior Court, and the estate of a deceased judge, and a bunch of lawyers. So why do these people who should know better and should have the training and should understand, why do they come to us? Because they know they need somebody that understands this stuff and that will do it correctly. They don't want to be caught in the do-it-yourself area. Let me tell you another little fun story about a case. So I'll call this the case of Aunt Mary. So Aunt Mary actually had a really good estate plan. She sat down with a lawyer, she wrote it, she amended it, she did a series of amendments. The last 4 or 5 months of her life, she got too sick and she tried to get to the lawyer, and for whatever reason they couldn't get their act together and they didn't do it. So little old Mary sat down. Can you see the handwriting on this? I know you guys are kind of far away, but she took her, this is her will, but she did the same thing with the trust. She scratched, and I want this, and she changed the percentages, and she wrote some people out. Now we've blacked out the name so you can't see who this is, but this is her actual handwriting, okay? So there she was in her backyard, modifying and amending her estate plan. All right, so we're going to take another vote. Who thinks that this is legitimate, would be upheld? Anybody? Oh, hardly ever. Who thinks it would not be upheld? Most people. You think this would be a loser, right? Well, the answer is nobody knows. 2 years later and $500,000 in legal fees, they're still fighting about it. The first people that got called as witnesses were handwriting experts. Was this actually Aunt Mary's handwriting? Right? So we had a big fight over that. The next set of people that got called in were forensic psychiatrists. Was she capable and competent of being able to do this? And then you got into the no contest provisions, and you got into the petition for instructions, and everybody wants accountings, and it's a hot, bloody mess. And all of this could have been avoided if Aunt Mary had simply reconnected with her lawyer, and the lawyer had prepared the form and done with some formalities. This is one of the reasons it's really important. We consider our clients to be like family. We stay in touch with you. We stay connected. We invite you to come back if you do a plan with us every 3 years just to make sure everything's copacetic. Hey, something change? You still good with your kids? You got a new friend? Is your trustee Joe still alive? You want to make a change? We want to make sure that the document works and that we're there for you. So, number 7, mistake number 7, no legacy protection. So, they often say that you are remembered by the last thing that you do in life. So how do you want to be remembered? Do you want to be remembered as the person that left behind multiple lawsuits for your family? that blew 6, 8, 10, or 20% of your estate in legal fees while your siblings and children fought over who gets to be in control, or who's in charge, or how this thing goes? Have you made any plans to avoid family fights? A little bit of time and effort, and you can save yourself and your family an absolute world of grief and heartache. And these are probably the most common fights that we see. I was talking to a client yesterday whose sister had the will, but she wouldn't share the will and wouldn't tell her anything, and she's going through mom's house and she's throwing everything away. We had to file a probate. She's filing a probate, back and forth, and it's a mess. With a little bit of effort and a little bit of security, a third party, you can prevent all this stuff. And you don't want to remember as nothing other than a lawsuit or a series of allegations. And the things that get said in these lawsuits is unbelievable. The accusations that siblings throw against each other is just really horrifying. So, ineffective planning. In summary, we haven't made any plans for the living or a death probate, right? We want to do something to keep ourselves out of the probate court. And I'll talk a little bit more about that in a minute. We haven't thought about nursing home costs. Have you anticipated this to be a problem? Have you set plans in place to avoid having to pay all those nursing home costs? Number 3 is we haven't thought about protecting our family from lawsuits, creditors, or divorce. Number 4 is we haven't thought about protecting our family from remarriage problems. Is your estate going to go to the pool boy or Susie Masseuse or somebody that you don't know? Number 5, we haven't thought about protecting those retirement accounts. Are your loved ones going to make bad decisions, make bad tax decisions, and not have a retirement because they just spent all your money? Number 6, big mistake, no protection with do-it-yourself or bare-bone plans. Are you going to make it worse by trying to do it yourself? Are you going to sign a document that actually does the opposite of what you wanted it to do? And have you thought of any way to preserve your family values and life stories so you're passing along more than your assets, but a little bit of life wisdom to the people that you love and support? So hopefully in the seminar, a thought like this comes to your mind. Yes, there's got to be a better way to do this, a better way to avoid all these things. Well, indeed there is. So let me talk a little bit about the correct way that you want to do it. So the main focus when we sit down and we think through these issues with families is we sometimes describe this estate planning as probate avoidance. How do we make this simple for you? How do we keep you as far away from the court system as possible? And for a lot of people, and especially if you own any real estate, the most important way to do that, or the most viable way, is to do something called a living trust. So what is a living trust and how does it work? And I'll explain that first, and then I'll get to my question on the difference between a revocable versus an irrevocable trust. All right, so the first thing you need to know about a trust is that it is nothing other than a three-party contract. We know contracts. In fact, you guys as realtors know what a three-party contract is. So most of us are familiar with two-party contracts, right? A sale agreement, buyer-seller. A lease, landlord-tenant. Those are two parties. An escrow contract is a three-party contract. You have your buyer and your seller, and you have the escrow agent. That's what a trust is. A trust is, at its heart, a three-party contract. So who are the parties? The first up are the trustors, or sometimes called the settlors. These are the people who create the estate plan. So Bob and Susan Jones create the Jones Family Trust. Or Scott Schomer and his wife Colleen create the Scott and Colleen Family Trust, or the Schomer Family Trust. That position will never change. The second position is the trustees. Those are the people that run the trust. Think of a trust like a little corporation. So who makes the decisions about what are the assets in the trust? Do you buy, do you sell, do you trade that stock, do you refinance that house that's in the trust? That's the trustee's job. Okay? Now for most people when they create trusts, they are both the trustors and the trustees. You can wear two hats. But we've also said, hey, if Scott can't do it, here's who I want to do it instead. If Scott can't do it, I want Colleen, my wife, to do it by herself. If Colleen and Scott can't do it, then I want my brother Eric to do it for us, right? And you have a list. So that's what the trustee position is. The third party to the contract are the beneficiaries. Who gets the benefit of the trust? Big fancy word, but benefit. That's what you're focused on. So for Scott and Colleen's trust, I don't know about your all's trust, but for Scott and Colleen's trust, we get the benefit. Isn't that good? It's our stuff. We get the benefit of the stuff inside our trust, right? But what we've done is we've also put in a list of what they call contingent or remote contingent beneficiaries. In other words, when I die, then who gets the benefit of my stuff, right? Most often what we're doing is we're talking about your kids or your loved ones, right? They get the benefit, but they only get the benefit after you're gone. You're the first priority. So, a trust is a third-party contract, three-party contract, and you are serving in all three positions. You're the settlor, you're the trustee, and you're the beneficiary. So you might be saying to yourself, wait a minute, I'm signing a contract with myself? That sounds a little crazy. Well, not really. I like to think of it as the best contract you will ever sign. Because it's a contract that deals with all the issues that we've been talking about today. Hey, if I need nursing home care protection, here's what the trust says can be done. Hey, if I get in an accident, here's who I want to make decisions about my assets. Hey, if I pass away, here's how I want my assets to go to my kids. They don't get them when they're 12. They may not get them when they're 25. Heck, they may not get my assets till they're 65. If people say that to me, we'll have that conversation. But you get to decide because it's your contract. You tell us what you want. We'll have a conversation. We craft something that works well and build something for you. So when you create this thing, a living trust is a revocable document. So you can amend it, you can change it, you can make any kind of decisions. So if you're leaving everything to son number one today, you could wake up a month from now and say, you know what, I'd like to split it between son one and son two. Or I'd like to give half of my estate to the greatest school in the Western Hemisphere, the University of Southern California. Right, Teresa? Caesar just got our marketing coordinator, Caesar, just got admitted there, so he's very excited. He's a Trojan. Anyway, but it's your contract. You can decide what you want to do with it. You can make those types of changes. Now, I was asked earlier, what is the difference between a revocable and an irrevocable trust? The irrevocable simply means you can't change. So revocable, change, no change. Change, no change. So if you write a trust that says everything goes to UCLA, you're stuck with it if it's an irrevocable trust. You can't a year later say, oh, I don't like UCLA anymore, I want it to go to USC. Too bad, you were stuck with it. In contrast to revocable trusts, change. And one of the reasons they describe it as a living trust is because living things can do what? Change. That's exactly right. So a living trust gives you the right to change. Now, why would you use one of these versus another? The basic rule is that you almost always want to be in a changeable document. Almost always. There has to be a good reason for you to want to do something that becomes irrevocable. So what is a good reason? Tax planning is a good reason. If you are worried about an estate tax problem, that's a good reason. If you are worried about asset protection, I had somebody ask me about asset protection. One of the ways that you get asset protections is you move assets into an irrevocable trust and you cut your ties with it, right? You build it as a little fortress. And also you can do this for the next generation. You can do irrevocable planning for the next generation. So as a general rule, you almost always want to default to this. Now, if you don't mind letting your heads explode just a little bit more, your living trust at some point in time becomes this. Can you imagine when it would become this?
When you pass away.
You guys are smart. That's exactly right. So you write a trust that says, while I'm alive, I can change it and do whatever I want. But once you're dead, who's there to change it? Nobody, right? It was your wishes, it was your wills, your decisions. Your ability to change it any further is lost, and therefore the document becomes irrevocable. Yes, ma'am?
Would that be true if you also become incapacitated?
Yes, except that you can regain capacity and then have the right to amend.
Oh.
Yes, but if you become permanently incapacitated, same thing happens. That's exactly right. Very good observation. Yes, ma'am?
What if there are two people that are on the trust and one dies? Does that make it irrevocable? Or?
That's another really great question. And the answer becomes, it's something you need to think about, and you need to look at the document. You can do different things. So I've had couples that have come to my office and say, excuse me, have come to my office and say, I trust my wife implicitly. And if she wants to go marry that pool boy after I'm gone, that's her business, and she can do whatever she wants with the money. On the other hand, I've had couples that have come in here into my office. I had one that came in about 6 months ago, and they were sitting on opposite sides of the table, and I sat in the middle. I said, that's kind of an unusual sign. Usually couples sit together, and they go, well, we're not sure if we're here to do an estate plan or get a divorce. Fortunately, they did an estate plan. But in that situation, you can write it in such a way that says, okay, we've lost one spouse. The survivor now has an obligation to cut the estate in half and put half of the estate into an irrevocable trust. And you may have, wow, bad planning on my part. Excuse me, I'll clean this up in a minute. You may have heard the term AB trust. Anybody heard that before? Is that a term anybody's heard before? No? So an AB trust is something where you start with revocable living trust, right? RLT, husband and wife. And then you have a death. So let's say the husband passes away, and this is your split. So the estate gets split into an A trust and into a B trust. And the way that you remember the difference between these two, the cynical way, is that the A stands for above ground,
Oh, no.
and the B stands for below ground, right? And typically the way that you would structure it in a situation like this is once you divide the assets, you then say the surviving spouse can still have some type of access to them. So perhaps you say the surviving spouse can get income, right? So not the principal, but they can get the interest or the income. Or maybe if they're desperate, they can get some part of the principal. Or sometimes we can even do controls where we say, okay, the A trust, I forgot who did we kill off. Did we kill off the husband? We killed the husband, okay. So the A trust would be the wife's trust in this situation. And the A trust, the wife has full, complete control to do whatever she wants with it. Sell, give it away, right, leave it to somebody else. But not this side. The B trust, if they had said, split it amongst our 2 kids, she gets support, and then the B trust goes somewhere else, or goes to the 2 kids. But you can set up, you can say independent trustee for the B trust. You can also say that if the spouse gets remarried, that if she doesn't have a prenuptial agreement preventing her from messing with the B trust, that you have to appoint an independent trustee. So there's all kinds of interesting ways that you can do this type of stuff. It was a great question, and I don't think the class wants to be here till midnight, otherwise they're done. So thank you. Was there, no? Okay, all right. So, all right, we're talking about trust, we're talking about the difference between revocable and irrevocable, and again, just to put a final point on it, at your dual marriage level, this is a revocable trust, a living trust. When you have a death of a spouse, the document has made the choice, the parties have made a choice that it splits. This still is revocable. This becomes irrevocable. And it's done both for tax reasons and also for asset protection, to preserve the assets, in theory, for the kids. That would be the idea. But also to give a fund for the spouse to survive on. Okay? Great stuff. Anyway, you create a trust, it's life as usual. You don't have to do separate tax forms, you don't have to file with the IRS, you don't have a change in property taxes. It is business as usual. You can buy and sell assets, you can trade them, you can refinance properties, the whole 9 yards. The trust is simply a standby device. It is your roadmap or your set of instructions for when I'm gone or when I'm incapacitated, what happens to me next. And none of it involves court involvement. So, what's the most important part of any planning or your planning? We think the most important thing is what's the most important to you. And what I mean by that is you need to spend some time thinking through this with somebody that has been down this road before. One of the reasons we both plan but also go to court is we see all the mistakes that people make with these things. We see the potholes in the road ahead for you. And we will bring these issues up if we think that you're doing unwise and make sure that it's planned correctly and that we capture the essence of what you are trying to accomplish. It's the most important thing. Because at the end of the day, these are the things that clients tell us are most important. Your family, your friends, your experiences, all these types of things. We want to make it simple. We want to give you a platform and an opportunity to pass along not just your wealth, but your values. So we like to think of this as a defining moment. How will you be remembered? Will you be remembered as somebody that left a mess behind, that forced your family into probate court, that ended up creating a lawsuit between your kids? Or will you be somebody that protected your legacy and preserved it and kept it organized for the next generation? This is why, seeing the pain and helping these families, this is why it's so important for us to educate people and help these people, because we want to see you do it right. We don't want you to be on the probate court side of the ledger. We want to see you on the planning side. So what do you need to do? How do you need to make this happen if you want to do something about this? If you've not planned or you've not looked at your plan in 2 decades or you've not dealt with this. And by the way, the thing that you need to know is if you're sitting in the audience going, oh, geez, I feel really bad, you're not alone, okay? One of the judges that I'm representing, her father was a very, very, very prominent probate lawyer in Los Angeles County. Yes, and that state is a bloody mess. You won't even believe the stuff that's going on. But it's not just me, it's not just her, it's not just Teresa, it's my family. About 10 years ago, we lost my father, and there's my father laying in his hospital bed. And there's my mother, I come to the hospital, and there's my mother yelling at him because the wills that they hadn't been updated since I was 10 years old, right? Your son's a trust attorney, and you can't be bothered to get this done? Yeah, that was a really fun conversation. Not. So, think about this, take some time, make it a priority. It's a really important thing. And remember, you don't want one of these. You want a plan that's designed to take care of your family. And funding. I haven't really talked about funding, so let me cover this topic. Somebody asked about trust funding. A trust that is not funded is like an ink pen without ink in it. Now, an ink pen is designed to write with, but an ink pen without ink is worthless. It does have one purpose. You can throw it at the person who wrote the trust for you, right? But other than that, it's not what it's designed for. A trust works the same way. And we see this all the time. We see this with attorneys. I'm fighting another case where a decedent didn't properly fund his trust. The lawyer washed her hands and refused to do any of it. And there was a $500,000 annuity sitting outside of the trust with a beneficiary designation from 25 years ago to his daughter that cut out 2 of the other beneficiaries. He was absolutely clear he wanted everything to go in thirds, and this asset was not funded. So if it's not funded in the trust generally does not control it. Okay?
With an annuity, though, doesn't an annuity automatically go to whomever the beneficiaries are designated? Is what you're talking about where there's a contest that happens over the annuity? Okay.
Yeah, that's a really good question. So there are some assets that you actually cannot fund into a trust.
So annuity is a common one. Another one is an IRA or a 401k. Okay, those accounts, IRAs, are actually little trusts. And if you pull the money out of an IRA, you pay tax, right? You know all that. So you don't want to pull it out and put it inside of a trust. But instead, what you want to be doing is thinking, how do all these things work together, right? Are they doing what I want them to do no matter what the circumstances are? So in this case, what this gentleman wanted to do is he had a trust, and then he had an annuity, and he had an IRA, right? And they were not all coordinated because the attorney didn't spend the time to fund or think about how to fund them properly. So the goal with the trust was that he wanted everything to go 3 ways. But on the IRA, he had it going 2 ways, and on the annuity, he had it going 1 way. So you had a hot mess. It didn't make any difference. So first thing you want to do is you want to make sure that you review these things to make sure they work. The second thing is you can often point these things so that they pay to the revocable living trust. But if you do that, you have to make sure you understand what it is and is it the right thing to do. Okay, so for instance, if you aim an IRA at a revocable living trust, you can force the IRA to get paid out immediately at death and incur huge tax liabilities. That's a bad result. But there are ways that you can structure a revocable living trust to do what's called a retirement asset preservation structure, so that it can be delayed and that it provides the creditor protection and all these different things, and also gets the benefit to make sure that it works together. So the most important thing, again, is you need to understand how all these things work together and make sure they do work together. And given that probably about 1/3 of the probate attorneys I know don't even understand it, it's good to work with somebody that does and takes the time to do that. So to me, that's the most important thing. Trust funding, let me tie this in quickly with the will versus the trust. So let me just back up real quickly. So we talked about a trust as a private contract, right? It puts your assets out separate, and it has the power to deal with your assets outside of the probate court. That includes while you're incapacitated and after you're gone. So it is commonly referred to as a probate avoidance device. Make sense? The will, on the other hand, has one function. The will is a set of instructions to the probate judge. It's very different, right? So if all you have is a will, and you have assets in your name when you die, you are going into probate court, right? And your will sets out who's in charge of your estate. That position is called the executor or the administrator, where the assets go, whether bond is required, these types of things. Now, when you do a good estate plan, does that mean that you only want a trust? Well, actually, no, it doesn't. What you typically do when you do a trust is you do something called a pour over will. I don't know if you've ever heard that term before. A pour over will comes from the imagery of pouring into. And we'll make a mess on the floor. Pour into. Right? You get the idea? And what its job is to pour any assets into the trust. So we make our decisions about how we cut up our assets, 3 pieces, 2 pieces, 1 piece. We make our decisions in the trust. Now, a well-coordinated estate plan reviews trust funding, here it is, trust funding, and makes sure that everything is in the trust. But people change, people make mistakes. Sometimes you go to refinance a house and the bank says, oh, we don't lend to trust, you got to pull it out. You pull the house out of a trust and you forget to put it back. This kind of stuff happens. If that happens, what the will says is, no, we're going to put it back into the trust. Now the bad thing about relying on the will in these circumstances is that you then have the 9-month period, 9 months to a year to go through probate. You have the probate fees and costs. That being said, there's another process that we can use with a well-created trust called a Hegstead petition. This is I'm pretty deep in the weeds on this. But there's another process we can use to minimize expenses and costs and all that other stuff. But you never, to me, it is malpractice to create a trust and not do a pour-over will. You always have to do the two of them together. Make sense? Okay? And did I cover the big questions on trust funding? That make sense? Okay? And it's kind of an art, and it takes time and effort, but we know how to do it, and we deal with all of it. Okay, so back to the big presentation. So a non-funded trust is like a pen with no ink. It's only good for throwing at people, not for writing or signing. So don't be fooled. We have the tenacity and the expertise, and we live this stuff, and we know how to take it and take care of it. So now you ask yourself, well, what happens if things change? Is this new tax law and exemptions going up, and what's going on? I don't even understand. Well, here's the reality of life. We talked about this before. Revocable living means change. It's going to change. But that's why we stay in touch with you. If something's important that's going to be affected, we're going to let you know. If there's a big tax law that puts you in tax trouble, we're going to send you out a letter and say, hey, maybe you want to come see us again. Maybe it'd be a good idea. And if nothing else, we can set up regular appointments. But we're going to know what's important, and we're not going to forget about you. We also always offer free consultations for loved ones or people that are incapacitated. So, somebody gets in that situation, you pick up the phone. We're always happy to be there for you and help you no matter what the situation is.